That only does not have the transaction.
May it please, my lord.
Yes.
Lordship, I may be allowed to make a mention for hearing item 16. I have taken the consent of the learned public prosecutor, Lordship. If it can kindly come up after 4 weeks.
Mr. Santiago.
petitioner with the consent of the other side. Praise for listing this matter after 4 weeks. The prayer is allowed. Yes,
Much
sir.
obliged.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 18.
See,
I pray that this matter be listed after 3 weeks.
have you informed the other side? It's arbitrary.
We have by registered post as well as it was published in the paper. So most probably, Lordship,
They're not appearing.
they have not appeared. So
Today also not.
today also they have not appeared, Lordship.
Okay,
Most
what do you want?
probably, Lordship, the petitioner, they may withdraw the
Okay, what do you
petition.
want to do?
So after 3 days, out of 3 weeks.
Okay, Mr. Yangravati, Lord Counsel for the petitioner. Praise for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Mashallah.
Please, Lordship.
Yes,
Lordship, I beg to mention item number 19.
yes.
Today, my senior has some personal difficulties. I pray the matter may be listed after 4 weeks, Lordship.
Mr.
Jamir.
Lord Counsel for the petitioner submitted his senior has some problem, some
Personal.
difficulties today. Hence pray for adjournment. To which Ms. Mary Nana Pinky has no objection to start. Accordingly, the prayer is allowed. List this matter after
4 weeks.
4 weeks. Okay.
Obliged.
May I please, your lordship? I beg to mention hearing item number 14 and 15, lordship.
My lord,
Okay.
in that matter, my lord, so what my friend is asking for an adjournment, but in that matter, there are certain developments have taken place in that matter. So my lord, I would request, I've got no objection for adjournment, but a record has to be called for because there is a judgment of the Honorable Apex Court. So I would like to, that after the motion matters, it won't take much time. So let this matter be called up. Because your lordship has to peruse the record. 14 and 15.
Lordship, but I'm appearing on behalf of the PPNIA, Mr. Lokesh Kumar, lordship. I have just an instruction to adjourn for 4 weeks, lordship.
Record for what?
My lord, this matter pertains to the validity of the notification issued by the MHA. And second issue is that the entire proceeding has been challenged before this honorable court in pursuance to the cognizance taken by the NIA special court. Now, what happened, my lord? Section 39 and 40, that is the two allegations against me, giving the money to the underground fractions. At that time, I was a DDO. What happened? The Honorable Apex Court has passed the judgment that as far as section 39 and 40 are concerned, if a person who is a victim of extortion, you cannot equate him with a perpetrator with a crime. As far as I am concerned, it is in the charge sheet, they filed a charge sheet and I have been portrayed as a victim. So how can you proceed with me under 39 and 40? That is the main issue. And the Honorable Apex Court has passed the judgment against the order of the division bench passed by this Honorable High Court.
So today the NIA is not present.
Lordship.
So in any case, it will not be possible then.
Lordship,
My lord, let the record be called for. The matter
It
has
was
been,
not called for, are they?
not yet,
Not yet.
not yet. Your lordship has to see the records.
Let the
lordship,
matter be called for.
lordship, I'm not
Not take up
endorsed.
the matter, just see the record and pass.
Yes, your lordship. Sir, I have come all the way.
You are mentioning on behalf of.
On
Lord
behalf of
PP.
the PP lordship, since
you
I'm
are-
not endorsed,
If
for any
if you have
further
an urgency
proceedings.
to leave, no problem.
lordship,
We'll just see the record and pass if required.
lordship. In that case, the presence
But
may be reflected also, lordship, on behalf. And also the submission made by the NIA, lordship. I have no objection on the
so this is in hearing.
Yes, my lord.
lordship,
listed
in the hearing stage, lordship.
So record was not called for. Why it was listed then?
My lord, I don't know. Because on a very couple of occasions, NI has not been appearing in this matter. Because the earlier these matters were under the branch office of Gauhati. But subsequently, NI matters with respect to Nagaland has been taken over by the branch office of Imphal. So I believe you are coming on behalf of the Imphal branch.
We'll just see the record, huh?
Lordship,
Okay, pass it.
lordship.
May please, lordship, lordship, I beg to mention item number 2.
Item,
Lordship, I pray that this matter may come up after.
item,
Two.
Two.
Yes,
After?
after 3 weeks, your lordship.
Worship,
Yes.
I have no objection, but my concern is the court order is complied with by the authorities. So this is contempt petition, lordship.
Have you filed your
So-
affidavit?
Lordship, I have not filed my affidavit, your lordship,
You're
but
praying for time to.
yes,
file
I'm
affidavit.
praying for time, your lordship.
How much time?
Lordship, 3 weeks.
Okay, Mr. What is the land counsel for the petitioner is present? Miss. Land petitioner. Is appearing on behalf of respondent.
All the respondents.
Okay. Appearing on behalf of all the respondents. Pray for the 3 weeks time. To obtain instruction. And to file affidavit. The prayer is in. List is matter after 3 weeks. Okay.
Much better. Lordship, again, item number 10. Item number 10, your lordship, here, the matter is under consideration. So your lordship, I pray that this matter may come up after 3 weeks.
My lord, this is the order which was because of their own submission. This honorable appellate court has closed the writ appeal. That is my annexure 7, page 49. This is 2nd June 2023, where the Finance Department have cleared for payment of the shortfall of the termination period.
Payment of?
That the salary during the illegal reversion to the fixed pay. In that finance is clear way
What
back
is the
on
seeking time?
2nd
Lordship,
June
what?
Lordship,
2023.
I place your, Lordship, this is the letter dated 13 August 2024. Lordship, we have already sent,
Okay, just take up there, let the matter be called for.
My lord.
See that,
Yes,
see and pass order. Don't go.
you want to close?
no, you cannot keep on playing with it.
No,
This is a-
Lordship, we
This
have,
is the court order.
we have,
Okay, well, we'll just let the matter be
Oh,
called.
Lordship,
Not
Lordship.
in the mention.
May I please, my lord?
Yes,
Lordship, I beg to mention item number 4.
yes,
If a week time
May
can,
pleases your lordship.
yes.
if a week time can kindly be granted, lordship to file by counter affidavit, lordship. I'm for
Yes.
respondent 1,
You're for? This is Muhajir.
lordship. Item 4, your lordship.
You are for? the
Petitioner for the
Okay.
petitioner.
They're seeking time, how much time?
1 week.
1 week.
I'm for respondent
objection.
1 to
1 week for what?
filing counter.
Mr. and so,
Yes, your lordship.
not a counsel for the petitioner is present. Mr. Ngame. Not a counsel appear now. Direct. Government advocate appearing on behalf of the state respondent, praise for further 1 week time to file a counter.
Lordship, I may prefer respondent number 3, private respondent.
Okay,
I haven't filed my affidavit, Lordship, it's under
we
preparation.
have already filed.
No, it's under
Okay.
preparation, Lordship.
And Mr.
3 weeks time may be granted, Lordship.
Okay, his name also, huh? Appearing on behalf of respondent number 3, praise for further 2 weeks time, to file counter affidavit. The prayer is enough, list is matter after 2 weeks.
3
Hmm.
weeks. Obliged, Lordship.
Much. Lordship, I also beg to mention item number 5, your lordship.
Yes,
Now, in this matter, your lordship, I may bring for respondent number 1. Your lordship, if 3 weeks time can be granted to receive the necessary instruction, my lord.
Santiago,
No, I have no objections,
Okay.
lordship.
Mr. Angame, land council appearing on behalf of the respondent,
Number 1,
number 1. Praise for further 3 weeks time
lordship,
to
lordship.
file affidavit on behalf of the respondent, to which Mr. Santiago. Petitioner has no objection. Prayer is allowed. List this matter after 3 weeks. Okay.
Obliged.
Lordship, I also beg to mention item number 9. Lordship, in this matter, I was appearing for respondent number 2, 3, 4, and 6. However, your lordship, the respondent number 4 as your lordship is already transferred out, and in his place, a new incumbent has taken over, your lordship. If the new incumbent can kindly be impleaded, my lord.
Can you, non-council parties are represented. So, Mr. Hangami, non-council for. The respondent submits that the respondent number 4 in the present petition has been transferred, and in his place, new incumbent has been posted. At this, Ms. Mika A, non-council for the petitioner, prays for allowing him to implead the new incumbent as a respondent party in the present petition. So the prayer is allowed. This is matter after
2 weeks, Lordship.
Hmm?
2 weeks.
2 weeks. Okay.
All right. May I please, Lordship. My lord, I beg to mention item number 6 on visa Mome. My lord, I'm informed that
This is your lordship. Lordship, I beg to mention item,
after 3 weeks, my lord.
You are in item? Item 6
6 years, my lord.
for respondent.
Yes, on behalf of visa Mome, I'm mentioning, my lord. I'm informed that he's yet to receive instruction. So
Okay.
kindly listen matter after 3 weeks.
Lordship, I'm appearing on behalf of G. Deka,
Okay, Miss
Berta Tep.
appears on behalf of Mr. G. The counsel for the petitioner stuff. Okay, Mr. Ibapong appearing on behalf of Mr.
Visa Mome, yes.
Counsel for the respondent submits that the respondent is yet to receive instruction and prays for some more time,
3 weeks time, my lord.
prays for 3 weeks time. The
Yes.
prayer is allowed. This is matter after 3 weeks.
My lord, again, I beg to mention item number 11 on behalf of LT Sanctum, additional AG, my lord. He's also yet to receive instruction, so kindly list the matter after 3 weeks.
Your Lordship, there's an interim in this matter.
Okay. Miss
Tushi Jimmy.
Lordship,
counsel for the petitioner is present.
Lordship,
You have four?
I have the instruction to appear on behalf of respondent number 5 here, Lordship. So
Okay.
I'll be filing a power and at the same time affidavit in opposition.
Mr.
So kindly grant us 3 weeks time, Lordship.
Okay, Mr.
W. Marshal, Lordship.
Wood appears on behalf of respondent number
5.
5 and prays for some time to file power. And to. Okay. The wakalat nama, stuff. And Mr. Ibapong. You are appearing on behalf of?
LT Sanctum, additional AG.
Appearing on behalf of LT Sangam, additional AG. Your prayer is
He's yet to receive instruction, so
No.
3 weeks time may be
prays
granted.
for further 3 weeks time to obtain necessary instruction. And to file. No, necessary instruction, in this, yeah, in the case,
Your Lordship,
just, okay. The prayer not object, necessary instruction and phrase for 3 weeks time. The prayer not objected, according, please this matter after 3 weeks, stop. The interim order pass earlier, so continue till the next date.
Your Lordship, LCR may be called in the meantime. LCR,
LCR, not called for,
not yet, Your Lordship.
you have been listed, yeah. So, in the present case, the perusal of the trial court record would be necessary. Accordingly, call for the trial court record. This is made after 3 weeks. Okay,
Much obliged.
May I please, your lordship.
yes.
Lordship, I beg to mention item number 3 of your lordship for hearing. your lordship.
Well,
Yes, your lordship. Lordship, with consent from the private respondents, your lordship, to the 5 matter be fixed on 24th of September, your lordship.
Okay. Mr. M. Solo. Now counsel for the petitioner. With the consent of the other side. Prays for adjournment of the matter and to be listed after
Your lordship on 24, your lordship.
Hmm?
24 September, your lordship.
24. Okay, just.
Lordship.
yeah. Okay, you have no objection on the prayer of Mr. Solo, current counsel for the petition and Ms. M. Sukri, for the Planet PP. List this matter on 24,
Your lordship, 24th of September, your lordship.
24 of September.
Your lordship, after 4 weeks. Your lordship.
Okay.
Much obliged.
May it please your lordship. Lordship, I beg to mention hearing item 17 on behalf of Walter Gupta. Lordship, I was informed that he has some difficulties to kindly list this matter after 2 weeks.
Okay, You have
No
any
objection.
objection? Okay, Mister,
YP.
you are Mister?
Manchong Konyak, appearing on behalf of my senior, Resimon.
Here on behalf of Learned Council for the petition
Second.
of Miss
Kiso.
submit that the conducting council, Mr. Y.P. Gupta, has some personal difficulties today due to which he could not appear. Accordingly, pray for adjournment and to be listed after
2 weeks.
2 weeks. They are not objected. So list is made after 2 weeks. Yes.
Please, Your Lordship, I beg to mention item number 7 and 8.
May please, Your Lordship. What if I beg to mention item number 7, my lord?
You are appearing in which item? It's not audible. Some difficulties. You are appearing in item
7 and 8.
7 and 8.
Lordship, here
I am
I'm,
for the petitioner, my lord.
Petitioner. You are seeking.
7 and 8, my lord.
Okay.
Lordship, I'm for.
7 and 8.
Under Vakalatnama, we are yet to receive the copy of the petition.
So have you served copy of the petition to the respondent? Advocates are appearing for on behalf of the respondent today. You serve copy? Ms. Sumi Kakoti, Learned Council.
No, my lord, not yet, my lord.
Stop, Mister.
No one's on behalf of respondent.
Yes, my lord. 3 weeks time may be granted, my lord. I will serve the copy in the meantime.
Already filed.
Yes, Lordship. As per last order, we filed our
Okay,
Vakalatnama.
Mister. Appearing on behalf of the respondent. Respondent number?
Respondent number 1.
Respondent. Some said he has not yet received a copy of the petition. Stop. Ms. Sumi, Learned Council for the petition, shall serve a copy of the applicant. And the petition. Applicant and the copy of the application. Yes. What is this? This is miscase.
Yes, miscellaneous case. Lordship.
Miscase in what?
My lord, restoration petition, my lord. Restoration petition, my lord.
What petition? It's not audible.
Restoration petition, my lord. My lord, a petition for restoration of the case, my lord.
Restoration. You have objection?
Restoration petition, my lord.
But we are yet to file the, yet to receive the copy.
You should have served. This is
Yes, my lord. Restoration petition.
You have objection to the restoration of the petition.
Yes,
It was
we'll
disposed-
file necessary affidavit.
Dismiss for non-prejudicial only. Is there any delay
Yes,
in
Lordship.
filing the restoration petition?
Yes, the continuation of delay, for
Delay.
continuation of delay, yes.
You want to file objection?
Yes, Lordship.
Okay. Shall serve a copy of the IE to the Learned Council appearing on behalf of the respondent within a week. Within a week, you copy, serve copy within a week. Within 2 weeks.
Lordship,
List
if
is made after 3 weeks.
4 weeks, Lordship.
4 weeks.
Yes, Lordship.
My lord, 3 weeks may be granted.
It's paid for list is made after 4 weeks. Okay.
Yes, ma'am.
Lordship, I also like to mention item number 13 on behalf of the appellant.
Highly oppressed, my lord.
Lordship, if this can come up after 4 weeks.
Hmm?
My senior has some personal difficulty. Item number 13,
You are for?
the appellant.
Have you informed the other side?
Yes, Lordship.
Lordship, I'm for the state.
Okay.
I'm for the state.
Only the state is the respondent here.
The private respondent is there, but he expired.
Okay, Mister.
No one saw on behalf of Nuksantila, the
Appearing on behalf of, Sami
Nuksantila
says, the conducting council, Mr. Nakun, the Learned Council for that.
appellant.
Has some personal difficulties today. Which did not appear in the court. So, and praise for
4 weeks time.
the gentleman of the matter for 4 weeks. So, Ms. Supreme, Nana additional agent has no objection. So, accordingly, the prayer is allowed. List is matter after 4 weeks.
Obliged, Lordship.
Yes.
For motion, item number 1.
No, no, this item 14 is also for adjournment. There has been this 14 and.
Yes, sir.
This is for adjournment only.
Your lordship, what happened in this matter?
Because there.
No, I understand totally. What happened is that matter is that in this matter, 14 and 15, the petitioner before your lordship was a government servant. He was a government servant. What happened? The NSE and K on fraction, they started collecting money from the government departments. And he was also forced to give the money. Now, what happened, your lordship? The entire proceeding was being challenged before this honorable court in 2018. The honorable high court granted stay. Exactly. Yes. The lordship, kindly see.
Any difficulty there? The records for.
Lordship, I have no instruction, Lordship. I'm just
Yes,
appearing
Your lordship,
on
why
behalf
I'm,
of the PP.
why I'm praying for the records, kindly see the judgment of the honorable apex court.
If you go for scan, the trial is going on there.
Trial is going on.
And scan copy of the record.
Let the scan copy of the entire records, because that is a normal procedure that has been adopted now. And why I am making this prayer, because my lord will kindly see the judgment which I am placing before your lordship. This matter, what happened, your lordship? My lord is there, the judgment which I have given. Yes, Crescito tape, right?
Yeah.
Page number.
Para.
Para, it will be 10. 10. What happened in this matter, my lord? They were the co-accused in this matter. Their bail was been granted by the special judge. Against their order, they went before the division bench. Statutory appeal under 21(4). Bail was granted by the special court. Under the same section 39 and 40. What happened? The bail was granted. They approached before the division bench in principal seat, Gauhati High Court. The honorable division bench dismissed the set aside the bail order. Against that bail order, they approached this honorable Supreme Court. There, the Supreme Court has said that yes, it is a fact that these persons have paid money. It's a fact. I have also paid money, but under extortion. So once you are under extortion, victim, you cannot be equated with the perpetrators under section 39 and 40.
Anyway, your only prayer.
Kindly call for the records, my lord. Let's go ahead, my lord.
Appeal Sangham, Lordship. On behalf of NIA, Lordship.
RC 116. RC 116.
RC
116. Special Judge NIA Nagaland.
can copy, that means it will take some time.
Well, let it be after 6 weeks. Interim order to continue, my lord.
I'm for respondent note 3 and 4.
Oh, right.
That in only, my lord. So, this.
My lord, interim order to continue. Pending proceedings against me who has been suspended. Against me.
Father order or the next day?
Pardon, my lord?
The hearing was for the father orders or his.
No, it was continuing, my lord. Continuing. I believe there was an order passed by this honorable court. If I cannot, I cannot able to recollect the particular date. Interim order to continue till the disposal of this matter. There was already an order. My lord. So I'm not sure on which date it was there. Because what happened, your lordship, there is an order passed by this honorable court in 14th, my lord. There were certain developments. Miscellaneous application, that is, it has become, that has become perhaps redundant at this point. No, that's why, exactly. Yes.
Obliged lordship.
My lord. Obliged.
For motion, item number 1.
No one appears. On behalf of the petitioner. List is matter. Next motion they will do. First step. This is motion.
From the supplementary cost list for motion, item number 20.
May I please lordship.
Yes.
This contempt petition is filed for non-compliance of this honorable court order dated 26/9/2023, wherein the state respondents were directed to regularize the service of the applicant petitioner within a period of 6 months, your lordship. However, the state respondents are still deliberately sitting over the honorable court's order, my lord, without taking any action. Therefore, this contempt petition has been filed, my lord.
Direction is for regularization.
Yes, your lordship. Court order is in page number 8, my lord, and extra 1. And the relevant paragraph is paragraph 9, page number 11, my lord.
Yeah, thereafter review is also there.
No, lordship, this IA the IA was filed for correction of,
Correction of the.
yes, your lordship.
Okay, regularization.
Yes, your
Not
lordship.
appointment.
Yes, your lordship.
So this is not for the appointment, not for.
Not for appointment, for regularization, yes, lordship.
Miss. Yeah, miss.
Atzla Kips.
R.
Atzla Kips,
Atsulaki.
my lord.
And counsel for the petitioner, stop. This is an application for initiation of contempt proceedings under section 11 and 12 of the Contempt of Court Act 1971. Relevant rules of Gauhati High Court rules. And Article 215 of the Constitution of India. After that, it will come. Read with Article 215 of the Constitution of India, read with relevant rules of the Gauhati High Court. Start. For Gauhati High Court 4. Non-compliance of the order passed by this court on 26/9/2023. So this 6/10/2023 is also to be mentioned, I think.
Yes, your lordship.
There, in that case,
There was a clerical error, my lord. Yes.
so that is for appointment, but then this 26/10/2023 is for regularization.
Yes, your lordship.
Stroke 6/10/2023. In what is the number?
IA 125 of,
No, no, WPC 187/2022. Okay, this is in IA.
yes, your lordship, IA.
Okay. Then write this number. 26/9/2023 pass in WPC so and so. And order dated 6/10, read with 6, is read with order dated 6/10/2023 in IA.
120. IA civil 120.
IA with bracket civil bracket close 1/25/2023. Stop, huh? Para, issue notice, returnable by 4 weeks. Stop. The petitioner shall take steps upon the respondent
During the course of the, my lord. During the course of the,
during the course of
yes,
the day.
lordship.
Okay. By a register post.
Yes, lordship.
Registered by a register post during the course of the day. Stop. This is matter after 4 weeks. Okay.
Obliged, my lord.
For motion, item number 21.
May I please, lordship.
Yes.
Lordship, this is an application filed under 482 CRPC, praying for question the criminal proceeding pending in the learned judicial magistrate first class on the ground that compromise has been executed between the accused petitioner as well as the complainant, respondent number 2. Lordship, here the complainant, the respondent number 2, also had written a letter of withdrawal to the learned judicial magistrate first class. However, since the sections leveled against the accused person is non-compoundable, the learned judicial magistrate first class has directed the accused person to appear before this honorable
Which
court.
one is not compoundable?
It's section 354
354.
CIPC. Yes, lordship.
So if the respondent has also, it's not a joint petition, but isn't it?
Yes, lordship.
Okay. You are for?
I'm instructed to appear on behalf of respondent number 2.
Okay.
State motion.
Okay. Miss,
No problem,
counsel for the petitioner.
lordship.
Also heard Mr. Angamilanet. PP. V. Angamilanet PP. Mr.
KKK.
Would appear on behalf of the respondent number 2, staff, huh? And Mr. Swenso, who appear on behalf of the respondent number 2, staff. Okay. This is an application under section 482 CRPC for praying for quashing of the criminal proceeding against the accused person. In GR 125/2022 under section 354 within bracket C of IPC. What is this case number?
Case number is 006 of 2022.
This is case number of which?
Kusama Police Station.
Arising out of PS case. Arising out of Kazama PS
Kusama
case number 006/2022. Stop. Issue notice. Returnable by
Lordship, I also have a prayer.
4 weeks.
During the pendency of the case, if Lordship may kindly stay the proceedings of the learned judicial magistrate.
Let us see the FIR. Case has already been submitted into charge sheet.
Yes, Lordship.
So what is the stage of the trial? Evidence. Charge framed against
Charge
accused.
already framed, Your
Already
Lordship.
framed.
Yes,
The
Lordship.
evidence.
Evidence is yet to start, Lordship.
Witness not examined.
No,
Yet
Lordship.
examined.
No, Lordship.
Someone issued.
On,
Someone issued to the accused.
yes, Lordship. In my annexure F,
You have
page 42.
page 42.
Yes. Point number 3.
So at the time of framing charge, why you did not pray for discharge?
Lordship, actually, we,
If you think there is no case, and then since the party has entered into agreement.
not till such time we could not get in touch with the complainant, respondent number 2.
You have not annexed the typed copy of the FIR.
No, Lordship.
No, you have to annex the typed copy also in the High Court. So in the charge sheet, yes, have you annexed the charge sheet?
Yes, Lordship. It's in
The
page
last,
65.
let us see the last one where. You have impleaded. The victim is a minor. Okay, not minor.
No, Lordship.
No problem. Okay. But then to stay, only stay in proceedings. Okay, this is bail order. I was looking at this. charge sheets. So praying for stay of the further proceeding against him. So this probably is not the full copy, and then the finding also only says on the basis of the statement of the witnesses, hence the light of above so and so charge sheeted.
Lordship, as far as the state is concerned, I think they have enough time. It's coming up on 1st October, more than 1 month. So the next hearing before the trial court is after 1 month on 1st October. So if
This can be
necessary,
called prior to that, before that.
yes, yes. After 4 weeks, naturally it will come before that. So
It's on October, so today, September, we can fix it within September.
yes,
And then perusal, on perusal of the record, if necessary, order can be passed.
yes,
You
in the
mean to
next,
say that?
on the next returnable date, Lordship. Okay.
Okay.
Yeah.
The. I've said, issue notice, returnable by 4 weeks. Okay. Have you received the copy?
We have received, Lordship.
Okay, you have also received the copy. Okay, since the respondents are appearing, no formal notice required to be issued to them, staff. The interim prayer shall be considered on the next stage, the next returnable date, staff. List is made after 3 weeks. Just a minute, and prior to that, no? Call for the scanned copy of the trial court record. Okay. Then the interim prayer shall be considered on the next day. List is made after. We'll say 3 weeks. Well, this, which court? Which court? The case is pending before which court?
Judicial Magistrate First Class, Kohima,
Kohima.
Lordship.
Okay, no problem.
Much obliged.
Mr. Agam, is it possible on within 3 weeks?
I think it may be possible.
Even 4 weeks also, because it, since the matter is fixed on October, it
Yes.
can come within September. We'll say 4 weeks. Okay, 4 weeks to ensure
Much
the records comes. No? Okay.
For motion item number 22.
My please, Lordship.
Yes.
Lordship, in this area, the petitioner is seeking for implement of the Home Commissioner Nagaland as respondent number 3.
What, Commissioner?
The Home Commissioner Nagaland Kohima as respondent number 3. Lordship, in COP 24 of 2022,
Okay,
here,
implement.
yes, impleadment.
Okay,
Yes. So the COP which is arising out of 21 of 2022, here the Home Commissioner is the respondent number 2.
respondent number 2,
Yes. In the writ petition,
in writ petition,
yes.
and in
So
the,
in the COP, we have not implemented
why,
respondent.
why?
Uh,
There was
Lordship,
no direction against him.
earlier we thought that he was not the necessary party, but this honorable court has also observed that for the compliance of COP,
Okay,
implement of respondent number 3 as necessary party. So
okay. You are for
Lordship, I am for respondent number 2.
2, 2,
Yes, Lordship.
and then you are going to implement this as
respondent number 3,
3.
yes.
Okay. Heard, Mr.
Abel, I am.
I've also heard Mr.
Second issue, Lordship.
For appearing on behalf of respondent number 2.
Yes, Lordship.
Fair. This is an application for implement of
Sri Vyasan.
Vyasan
Yes, Lordship.
IS, the Home Commissioner, Nagaland, Kohima is the respondent number 3 in COP number 24, in
24, Lordship,
2020,
2020.
arising out of, in WPC number 21, 2020. The writ petition is also pending, still pending.
Lordship, writ petition has been
No,
disposed.
COP is pending.
Yes,
Lordship,
COP is pending.
Okay, stop. It is submitted that the Home Commissioner was a respondent number
3
in the writ
in
petition.
COP. He was
No.
respondent
Home
number
Commissioner
2,
not yet implemented.
not yet implemented.
No,
Lordship.
in the writ petition, he was,
Respondent number 2.
okay, Home Commissioner Nagaland was respondent number 2 in the above writ petition number 21, 2020. But he was not included in the COP number 24. 2020. Now the court has directed you to implead. By which order?
Lordship, the court has not ordered specifically, but the court has also observed that for the implement of Home
By which
Commissioners
order dated?
order.
As it was believed that he was not a necessary party. However, by an order dated, this honorable court observed that order dated, huh?
May I please, Lordship?
Yes,
Lordship, in COP, we have complied with the order. And we have already sent the petitioner's name for approval to the
Okay.
commissioner. But so they are impleading the commissioner, home commissioner.
Yes.
The petitioner are applying on compassionate ground. In the Department of PHQ, Police Department.
the observation is, order dated 9/7.
Lordship, as I said, there is no specific order which has which this court has directed, but it has come to observe that for the compliance of this COP, the Home Commissioner, who is the respondent number 2 in the PPC, has become necessary. Lordship, there is no, it has not been reflected specifically in the order.
However, since the letter dated 4/6/2024 has been written to the Home Commissioner seeking the government direction stroke approvals for appointment of the petitioner or respondent number 2.
Respondent number 2, yes.
Who is respondent number 2?
In WPC, Lordship,
No, approval of the appointment of the respondent number 2 on compassion. Is a
Lordship,
no,
the
the
petitioner,
petitioner is seeking for on compassionate ground. In grade
So
4
now,
class, Lordship.
now that this order says, direct approval for appointment of the respondent number 2 on compassionate ground.
Lordship,
this
we
is
have
the
already
petitioner.
complied with the order of this honorable court in
Okay.
COP. And
So,
since
we
we
are
have already
pending
complied
update.
and we have sent for approval to the government, so they are impleting the Home Commissioner.
Yes, Lordship.
Okay, pending before, your Home Commissioner seeking the government direction approval for appointment of the petitioner on compassionate ground. The Home Commissioner is now a necessary party to be impleaded. I think has been a substantial compliance of the judgment in order. And at this, since they are on the process of compliance of the order passed by this court, by the respondent,
Yes.
whether the impleadment of the Home Commission at this stage is required, necessary.
Lordship, they have said that they have submitted the letter dated 4/6/2024. But Lordship, it is, they just say that by washing their hands, they just said that they submitted. But Lordship, during the last occasion, the leading counsel of this petition has submitted that if sometime may be granted to the respondent for the compliance, Lordship. Mm.
Oh. So, the prayer is allowed. Okay. And since the Home Commissioner, Nagaland, Kohima, was a respondent, he was a respondent number 3 in the writ petition.
The Home Commissioner, respondent number 2, Lordship.
2
Yes, Lordship.
was a respondent party in the writ petition. The prayer is allowed, huh? Okay. So let's Shri Vyas RRS, the Home Commissioner of Nagaland, Kohima, be included as respondent number 3 to the CO to the COP number 24/2020. Stop. Stop the. Okay. With the above this IA stands allowed and disposed of, and in the main, add Mr. His name, and Mr.
Sukajish Lord.
For the respondent number 2, stop, in view of the order passed today in IA 122, the petitioner shall amend the course title of the COP, the course title of the COP, course title of this petition by by inserting the newly implemented respondent number 3 from Impleaded Home Commissioner, Nagaland. His name. So this one, so IS Home Commissioner Nagaland as respondent number 3. Stop. Stop. And take steps upon the newly implemented respondent number 3 by a registered post with ID within a week from today. Stop. Comma. Sorry, stop. Para. Is prayed for, comma. Please this matter after.
After 2 weeks, Lordship.
So you you are appearing on behalf of Longkumar.
Yes, Lordship.
Okay.
1 and 2, Lord. N. Kumar. On behalf of N. Kumar, Lordship.
So it is in the earlier occasion is submitted that it is still awaited. It is still awaited.
Yes, Lordship. We have already sent the
Okay.
petitioners for approval to the government.
This is matter after 3 weeks. Okay.
Obliged, Lordship.
Obliged, Lordship.
In the meantime, you correct, file.
For motion, item number 23.
May I please, Your Lordship?
Yes.
This IA is filed for deletion and replacement of respondent number 2 and 3. Respondent number 2, who was the 10th Commissioner and Secretary PhD, was retired and has been replaced by the new incumbent as well as with the Chief Engineer PhD, my lord. Your Lordship, here the nomenclature for Commissioner and Secretary PhD has been changed to Principal Secretary, Your Lordship. I've also mentioned.
Okay.
So-
Miss. Your miss.
Arts like keeps, my lord.
Oh, this is item 23. Katsula Gibbs, not a counsel for the petitioner. Start. By filing this, the applicant prays for the applicant submits that the earlier incumbent. Who is the earlier incumbent?
The earlier incumbent is Dr. Mawati Iyer.
Dr.
Mawati Iyer, yes. The Commissioner and Secretary. Yes.
Sorry, the respondent number 2.
Yes, Your Lordship, respondent number 2.
Dr. Mawati Iyer, IAS. And respondent number 3.
Respondent number 3.
Repang Gyampa Longkumar,
Lordship.
Chief Engineer, PhD. No, IAS Commissioner and Secretary to the Government of Nagaland, PHE. Department and respondent number 3, Engineer Repangampa Longkumar, Chief Engineer, Public Health Engineering Department, Nagaland. In civil contempt number 5, 2024, has been transferred.
Retired,
Oh, sorry.
Retired.
Has retired
yes, your lordship.
during dependency of this
Case, your lordship.
Okay.
Contempt petition.
contempt petition.
Yes, your
Stop. And in their place, Sri E.
E. Monpemo Patton,
Monbemo Patton, IAS,
IANAS.
IANAS, principal, has been posted as Principal Secretary, Public Health Engineering Department, Nagaland, Kohima. And Engineer L. Leyang
Chamnyungan,
Chamnyong, Chief Engineer, Public Health Engineering Department, Nagaland, has been posted respectively has been posted and praised for their impleadment is respondent number
2 and 3 in the contempt petition.
4 and 5. It should be 4 and 5.
Your lordship, this is for deletion and replacement.
Deletion and
Yes, if the respondent, the earlier respondent may be deleted, respondent number 2 may be deleted and replaced by the new incumbent, my lord.
then in that case, the entire thing has to be changed. They will be implemented as respondent numbers 4 and 5 only.
Your lordship, then I have to change the application because I have stated as respondent number 2 and 3.
Deletion, because that will, then let that be remain.
Lordship, then
So
your
there will
lordship.
be, because the moment you include anyone who comes.
Yes, your
it will
lordship.
be the respondent number 4,
Yes,
5, 6,
lordship.
it will increase.
Yes,
So that-
lordship.
That will remain as it is.
Lordship.
Okay.
Yes, lordship.
The prayer is, the prayer is allowed. Let Sri E. Monbembo Patton, IA and AS, Principal Secretary, Public Health Engineering Department, Nagaland, Kohima, be implemented and Mr. Engineer ER L. Leyang Chamnyungan, Chief Engineer. Chamnyungan, how do you present?
Chamnyungan.
Pronounce? Chamnyungan.
Yes, lordship.
Chamnyungan, Chief Engineer, Public Health Engineer Department, Nagaland, Kohima, be implemented as respondent number 4 and 5.
Lordship.
Stop. With the above this, I stands disposed of, and in the main,
Yes, lordship.
News are Atsula Kids. Non council for the petition start by an order okay. It is today, or by I order date is today's. It passed in IAC number 1, 2, 3. The prayer for implement of Sri E. Monbemo Patton, write that again, and Engineer L. Leong has been allowed as respondent number 4 and 5 in place of the earlier respondent number in place of Dr. Maungvati Iyer, respondent number 2, and engineer Ripang Wampa Longkumar, respondent number 2, respectively, respondent number 3 respectively. So, in view of the petitioner say file, petitioner say file amended post title by impleading the above respondent and take steps upon them by a register post with AD within a week from today.
Lordship.
You file amended.
Yes, Lordship.
Amended post.
Yes, Lordship.
Least,
After 2 weeks, my lord.
least is after 4 weeks.
4 weeks. Lordship.
Okay.
For motion, item number 24.
This is also for impleadment of deletion and impleadment of respondent
deletion.
number 1 and 1, 3, and 4, my lord. Same prayer, my lord.
Okay, hard miss, same, by this IA, the petitioner prayed for deletion of Srimati Chuvansang La Ana IAS, respondent number
1.
1, and engineer Rosu Ketso, respondent number
3.
3, and for impleadment of and 4 also.
Yes, your lordship, 4 as well.
That will be this is IAS respondent number 1, engineer Krosu Retso, respondent number 3, and engineer Kevide Nakro, respondent number 4, and impleadment and for impleadment of Sri Anup Kinchi. Why their name be deleted? They are also retired.
Retired, your,
And
yes, lordship.
during the course of during the pendency of this court, they had retired, and in their place, Sri Anup Chinchi IAS has been posted as the commissioner and secretary to the government of Nagaland. No, which one?
Commissioner and secretary to the, yes, PNR, your lordship. Respondent number 1.
No, Sri Anup IAS, okay.
Retired by
IAS.
2000, yes.
Has been posted as the commissioner and secretary to the government of Nagaland Personal and Administrative Reforms Department, Nagaland, Kohima. Mr. Okay, engineer PI Imna Ao. The engineer in chief, Public Work Department, Nagaland, Kohima, has been posted. No, engineer PI Imna has been posted as the chief engineer.
Engineer in chief.
Oh, sorry, the engineer in chief, Public Work Department, Nagaland, Kohima. And engineer Swarai Meru has been posted as the chief engineer, within bracket R and B, bracket close, Public Work Department, Nagaland, Kohima as respondent, sorry, Kohima staff, and praise for impleading damage. Respondent number. It will be 5, 6, and 7.
Yes, it will become 5, 6, and
5, 6, and 7. To the. This is in contempt petition,
Contempt petition number 5 of 2023.
5 of 2023. The prayer is allowed. In view of the above, the prayer for deletion and in deletion of the respondent number 1, 2, 3, 1, 3, and 4, and for impleadment of the new incumbent is respondent number 1, 3, and
5, 6.
5, 6, and 7 are allowed. Stop. With the above this IA stands disposed of. Okay. In main again, admission, so and so on. In view of the order passed in IA. Order passed today in IA number 1, 2, 4. The Miss so and so, counsel for the petition was selected. Sorry, no. File an amended post title by impleading Sri Anup Khichri, by inserting the newly impleaded respondent number 5, 6, and 7, and take steps upon them by a registered post with AD within a week from today. Stop. This amendment also, and in this step also you should
Lordship.
take within a week from today.
Yes, your Lordship.
After amendment, you have to take the steps.
Yes, your Lordship.
Okay. List this matter after 4 weeks. Okay.
Much obliged, my lord.
For admission, item number 3.
Yes.
Lordship, I am appearing for a petitioner.
Yes. So state respondent was to file affidavit.
Lordship, in that case, can you grant us 3 weeks time, Lordship? To file affidavit?
You are Miss
Berta Tep.
Berta Tep. The counsel for the petitioner is present. Mr. Andami appearing on behalf of the respondent, state respondent, press for further 3 weeks time to file affidavit in opposition. Prayer not objected. Accordingly, the prayer is allowed. Please take matter after 3 weeks.
Lordship, let this be the last chance to file the affidavit.
Okay. Last chance.
Yes, Lordship.
Are they also given?
Yes, Lordship.
Okay, Mr. K. Angami, counsel appearing on behalf of the state respondent is given further 2 weeks time as a last chance to file affidavit in opposition. List is made after 3 weeks.
Obliged, your Lordship.
From the supplementary cost list for admission, item number 25.
Lordship, this will require some time, so I pray that this matter may be listed after the usual matters. It will take some time, Lord. After the listed matters, Lord.
Yes, prayed for by.
Your Lordship, I will take it up today, Your Lordship.
Today itself.
Yes, but after some time, Your Lordship, because it will
What
take
is
some.
this matter?
A bail application, Your Lordship.
For bail application?
Yes, yes, Your Lordship. There are one
This
thing
I think
matters.
is one more. After this then?
Yes, after this, Your
Okay.
Lordship.
For orders, item number 10.
I think not mentioned.
My lord, what happened is this. They are producing one document today.
What is this document about?
They are saying that they have forwarded the case to the principal director, treasuries and accounts, Nakalan Kohima, way back on 13/8/2024. My lord, the issue is this.
Just a minute. Regarding status of the content. So the petitioner's name is Srimati Yezano.
Yes,
So her name also has been forwarded.
my lord, that is what I'm trying to see.
Hmm.
My lord, the petitioner filed one writ petition
Hmm.
against her illegal reversion to the fixed pay.
Hmm.
This honorable court first writ petition rejected, review also rejected. Then the petitioner have to come for a writ appeal. Appeal allowed the writ petition. However, she was not paid the,
Appeal allowed?
yes, by the division bench.
Appeal was allowed.
Yes, due to that, she was reinstated. But
Appeal by whom?
by the
Okay.
petition.
Okay. All right.
However, the illegal reversion period was not regularized, nor the salary were paid. So the petitioner again have to approach this honorable court for the back wages. This honorable court allowed the petition partly that prior to 3 years of filing up the writ petition for the back wages, she will be given that up to 3 years.
Prior to the filing of the writ petition.
My lord.
Hmm.
If it is not complied with within 3 months,
Hmm.
9% interest will be liable. That was the stipulation.
Hmm.
So against that order, the petitioner filed writ appeal number 4 of 2023.
Against that order.
Yes, it is not against actually, because partly I was allowed.
Hmm.
At that time, my petition may be seen, page 49. The government came up with this later, page 49. Annexure 7.
Yes. What is this? Statement. No. This is.
Right after the statement, yes.
Yes. No.
To the home commissioner, actually, it should be commissioner. Nakalang Kohima, writ appeal number 4, such and such, in connection with writ petition 169, such and such. Sir, I am directed to refer to your later number such and such, and the above stated subject into convey the following. Since the service of such and such has been reinstated with the prospective effect, she is entitled to salary after the relevant period from 4/7/2011. In
Court allowed.
because of dear placing this record before the appellate court,
Okay.
this honorable court, page 50, writ appeal 4 of 2023, dated 15/11/2023. it was closed because of 2nd June 2023 order. Paragraph 4, page 51. In the communication bearing number such and such, it is mentioned since the service of the writ appellant, writ petitioner has been reinstated with retrospective effect, the appellant writ petitioner will be entitled to the salary after relevant period from such and such, and the Home Commissioner Nagaland has been directed to take necessary action in the matter accordingly. Such and such, writ petitioner has submitted that since a decision has been taken in the manner mentioned in the communication dated 2/6/2023, the grievance of the appellant petitioner appear to have been effectively addressed. She has thus submitted that the writ appeal can be closed, however, reserving the liberty. So the respondent, what they are playing with the court. Way back in by 2nd June 2023. The petitioner will be paid her back wages. Accordingly, this honorable court petitioner have considered, yes, if it is going to be complied with. That was way back on 15/11/2023. Then what the present document is showing, they are saying that you've washed up your hand, handed over something to the somebody. Here, the duty of the commissioner not only is to pay the back wages, which was sanctioned by the Finance Department way back in 2023. And today they are producing this 13 August 2024. That means they've just sent it.
Lordship, we have prepared and sent it to the treasuries and account Nagaland, Your Lordship, to draw the money, Your Lordship. So if we have not written to the treasury, from where would we draw the money, Lordship?
This is the undertaking before the appellate court. Now they are saying that some 10+ days back, they have written a certain document and they want to wash up their head. Page 49 is clear. Because of this, the appellate court has closed it. Through this, honorable court has been misled all along.
This is for payment.
Yes. Your
Yes.
Lordship.
Okay,
Yes.
so they have taken steps.
That is what I'm trying to see. Way back on 2nd June 2023, the finance have already given the clearance. That is why the appellate court says that yes, since it is,
Now, what is your objection to this?
my lord, what I'm saying is this, the 2nd June 2023 approval given by the,
No, just a minute, sir. 1 second.
if
Have
they
you
are
seen- Have you seen
seriously,
this letter?
yes, I've
What the
received it.
letter says?
What they are saying is that it has been sent to the what not what. They are supposed to go and get the clearance.
They're supposed to?
They are supposed to go and get the clearance as per the court order. That is what I am trying to see. They are saying that way back on 13 August 2024, they have written a certain letter.
No.
Now, they have taken a stay for payment. Is your case covered here?
No, what I'm trying to see is this.
Your case, it appears that your case also covered.
My lord,
Her name-
that is what I'm saying. Yes.
So along with the required document in respect of so and so.
Yes,
This is you.
this is my case. Yes.
Yes.
What I'm trying to impress upon your lordship is this.
Hmm.
Way back on 2nd June of 2023, the finance department have cleared this particular issue. When this was placed before this appellate court, we agreed, yes, if they are going to comply with it, we are ready to consent for those closure of the writ appeal. So now 22nd June 2023 issue is they are writing on 13 August 2024. They are playing with this honorable court. Page 49 may be seen. On 49 passes, page 52. This honorable court has closed the writ appeal.
So your lordship here, if we read the letter dated 13 August 2024, within no time, your lordship, the petitioner will be getting her dues. Lordship, because now once the treasury passed the payment or clear the payment, your lordship, she will receive her payment, your lordship.
So what is your objection here?
Well, now what I'm trying to see is this.
They are paying. They have prepared.
Yes.
Sent.
That is what I understand, but what I'm
Whether
saying,
they approve or what they.
that is what exactly they should appraise your lordship.
Lordship,
Whether.
He cannot say that
This
we
has
we
been
have
sent-
written
this
it to
is
somebody.
information.
this, your lordship, this is the order
Let them come in,
Your
show
lordship-
what they have done.
from 4/7/2011. Everything has been worked out, your lordship.
Yeah. Everything.
That has been placed before your lordship long time back.
No, that's the letter 2024 August.
The period from 2011 itself.
Yes, we have prepared everything we have
everything.
said.
Yes,
So the best.
it was
page
placed
four
before
has
your
been worked
lordship.
out.
That
Worked
was
out
placed
till
before the
to
lordship.
till
Now only I'm placing.
1/12/2023. So this will be paid now to you.
Yes,
That is what I am
In no
saying.
time.
What I'm saying is this, my lord.
Hmm.
He themselves have cleared it way back in second
No,
zone,
no, we have-
2023.
no,
They are playing with it all
no,
along.
lordship, it is my learned friend has misconceived this letter. This letter says that the petitioner is entitled to salary with effect from 4/7/2011. There is no clearance, your lordship.
4/7/2011.
Yes, page 49. Since the service of Srimati Yezano has been reinstated with retrospective effect, she is entitled to salary of the relevant period from 4/7/2011. You are requested to take necessary action on the matter accordingly. So accordingly, we have prepared the areas, the less amount, your lordship.
Prepared since 4/7/2011 only.
Yes. So your lordship, this letter talks about that the petitioner is entitled for salary.
Yes.
Yes. So after that, only the preparation has to start. So we have started and now the matter is pending before the treasury. So once the treasury pass the amount, your lordship, she will get her payment.
My lord, in that line, the presentation, page 44 may be seen. These people have placed this
Yeah,
on
what is
record.
your problem with this? This they are paying since
Let
2011.
it be
only.
within a certain period of time. They cannot just say that way back
You
in
see this order,
13 August, we have written a certain letter to somebody.
13 August.
Yes,
13 August 2024.
yes.
So 2024 is only just 2 weeks back or 1 week back only, your lordship. Yes, and today is 27th of August 2024. And that letter is 13th of August 2024.
So this order, have you seen this order in person to finance department so and so? The refixation of salary in respect of your petitioner reinstated as beyond at extra assistant commissioner office with retrospective effect from 4/7/2011 is done as under. So from 2011 to 2023, they prepared.
Yes, earlier also they have placed this on record by filing affidavit in
Now,
opposition.
what is your objection now?
My lord, what I'm trying to see is this. Way back in 2017,
Forget it. They have prepared it now. You want the salary.
my lord, let them give a assurance to the court.
Or they're
because-
giving assurance. I think they are taking steps. They have taken steps. This also, and then here also communicated. You just see once, just show him once. This is what they have prepared, worked out. They worked out. They have. Just see that page. No. See that page. That one. That is what they have worked out. And
This is totally opposite to my the present petition. See,
I have no.
what he have placed before your lordship in page 44 of the contempt petition, the present contempt petition. This is what he have placed, your calculation. Page 44.
These calculations not yet paid to you.
This calculation, there was a different
You have
calculation.
objection to the calculation.
I have nothing to comment as of today because I don't have the copy.
Okay.
Page 44 may be seen of my present petition,
Hmm.
where they have given the calculation said. page 47 to 48.
What is that?
That is your calculation earlier.
This is,
This was filed in the affidavit in opposition, which was received by the petitioner way back on 2022. Whether it tallies with the affidavit filed before this court or not, that I cannot say. Earlier, you've already placed a calculation before your lordship, page 44.
Yes.
Lordship,
Which was received
Yes.
on
Yes.
20th
Lordship, right now,
2022.
after the treasuries and account made clear the payment, your lordship, and if the petitioner feels that it is lesser than what she ought to get, then she has a new course of action.
Step action on
And
that is
that-
not now.
Yes, in
Now
doing
soon have the
this,
figure
yes.
also. And they are paying
In the
worked out.
affidavit in opposition, they have already given the figure. Earlier proceeding, page 44,
You have objection to this?
an additional affidavit in
Do you have
opposition on
objection to
behalf
this?
of.
They have worked out, they have done.
They have not furnished me the copy. So I have nothing to comment.
This is contempt only, so calculation, let us see, calculation is different. They are doing, this treasury account.
If
that
they are,
is section they are
please,
doing, and if you are not satisfied with that,
My lord,
that will cause,
if
you
they
take action
place a
with that.
wrong affidavit in opposition in 169,
Okay, hard, Mr.
let them give a certain specific period of time.
Hmm.
You cannot keep on playing with it.
I'm-
This court order.
No, Mark, this is item. Okay, okay. Or Mr. Inti Longson. Council for the petitioner. Stop. Also for Ms. Sukri. Additional AG appearing on behalf of the respondent. Staff. Para. Ms. Sukri. Council for the respondent has placed letter dated 13/24 addressed to her by the Deputy Commissioner Headquarters. Whereby it shows that the just a minute. Whereby it is conveyed that as per the direction of this court, the less drawn area pay bill has been prepared by the Deputy Commissioner Newland. Dated 37/2024. And the same has been re-forwarded to the Principal Director, Treasury and Account, Nagaland, for payment. To the petition. So this, how long probably it will take?
That is what, my lord. That is
Lordship,
the-
for that,
This was-
so
this
I
was
don't
in
know.
the,
Yes,
July and then they inform to you on August.
Mm.
So probably say how long it will take.
Or who knows, by now,
Okay.
petitioner also might have received it, your lordship. I have no instruction on that. And treasury and accounts is not a party respondent here. So lordship, I'm not appearing for.
And submits that since the matter is pending before the treasury, some more time maybe. Provided for compliance. Huh? So since you just go through, they have worked out. And if you have grievances against the working out, regarding the amount they have calculated, then new course of action will arise. But for the timing, since they have worked out and it is forwarded to the treasury and the treasury is pending before the treasury only. So now they can't do, they can't.
One of the financial commissioner, who is the head of administrative head of the
When
department,
it is
is a
forwarded to the
respondent here.
treasury, it will come back,
My lord,
I think.
what I'm saying is this. Financial commissioner is the administrative head of the department for the treasuries in accounts. So he is respondent number 4 before your lordship in this petition. So let the direction be given to them. Because treasuries in accounts, administrative head is the financial commissioner. So they cannot take the play that
Lordship, let
direct
this
secretary
matter-
is not
The
a
prayer is allowed. Okay, the prayer is
Yes.
allowed. This matter after. You just obtain whether the pay.
Yes, yes, your lordship,
This
yes.
is matter after 4 weeks.
Yes, lordship, I may allow to take
Yes,
that,
yes, take it.
original.
Give it.
calculation sheet will be
They have
furnished to me
worked out,
also.
And probably, let us hope that very soon you'll get. Then is out. Since it is pending before the treasury, and then again directly to the commissioner of finance or commissioner, whichever, it will be difficult. So since they are working and in pressurizing.
In that
somebody-
case, my lord, let the commissioner hold
Yeah, this is.
be directed. Respondent number 6.
No, your lordship, no. Much better.
Yes.
For admission, item number 25.
Yes,
Yes,
Uh,
lordship.
record as called for or what?
Yes, yes, CD was called.
CD, case
Yes.
diary. You have received the case diary?
Yes, in the form of
Instruction. So what is the status?
investigation is going on, lordship.
Investigation.
Yes,
So it's been, I think it's long, I think it's been not yet completed.
not yet.
Okay. So, but then nothing has been recovered from this present accused person?
Nothing
No,
is
your lordship.
recorded, but as per lordship, if my lord turns the page, right after the page in,
Yes.
my lord,
Yes, which one?
here at the
During the preliminary?
yes. During the,
Accused.
yes,
The present accused is Baharuddin.
no, James Shanjang,
James Samjang.
yes,
So he supplied.
yes,
So he himself is admitted probably.
yes, yes.
And during the examination, he himself is stated that, and then
Yes,
in your
yes.
petition also,
Yes,
in petition also, you have admittedly. you
I have delivered
admitted-
one bag, your lordship.
Huh?
I have delivered one bag
One
of
bag,
yes
yes,
of
that-
co-accused, but
that
the
is-
contents
that-
I do not know.
That being in admitted position,
Yes, sir.
then you see, it will be little difficult.
Yes, lordship, and he was also like make a profit 49,000 out of
Why
49.
why did that
Those
49,000
are
recovered from
allegations,
him
your lordship.
Yes, and not
No.
report for him, but by his own admission.
on admission only, not recovered?
No,
Even after his arrest also, it was not recovered, not seized. This 49,000, what he have,
Oh, no, that's not.
No,
his.
Your Worship.
But he says that he's making the use of that for, if you look
but
at
this
his,
admission is, okay,
but this is.
before the police, but then he
Yes,
himself has admitted before this
Yes,
court also.
yes. And now, this is not his first time. If my lord,
Yes, yes. Earlier also he was arrested, but then he was
Yes,
On
Your
bail,
Worship, I've
Lordship.
made a specific statement on this in my
acquitted
petition.
or what?
Acquitted, Your
no, no.
Yes, no,
There's nothing on record to show that
Lordship,
criminal case is pending, Your Worship.
Lordship, if my lord turns to
Yes.
+3.
Yes.
Ac-
Accused James Samson was found arrested on another case where
Way
was
back in
on
the year
bail.
2017, Your Worship. 2017.
So detail will be submitted during charge sheet.
Yes.
Yes, Your Worship.
That means
It's not
the
pending.
detail has not yet been found out.
Yes. There's nothing to show that a criminal case
Not
is pending. Your Worship.
70s, Lordship. It is, as per his statement, certainly not 70s.
My statement cannot be used against me at this moment, Your
See,
Worship.
What
Just for
investigation
conviction,
is
Your
going
Worship.
on, Lordship?
If we can go in detail, Your Worship, I can, if Your Worship,
What detail?
a detailed hearing, Your Worship, then,
Yes,
okay.
but the, what type of detail hearing you want?
Your Worship, the application of section 37, when section 27A applies, Your Worship, and the interpretation of section 27A, Your
So
Worship.
this registered section is
Only two sections, Your Worship.
Only two
27
section?
Yes, Your Worship. 27,
27 and
27A and 27A, or 28,
27A probably not made out.
not made out, Your Worship.
27A, whether 27A is
But
applied
Lordship,
to-
still investigation is going on, Lordship.
However, Your Worship, the
No,
facts-
27A, let us read the 27A.
Yes,
A.
Your Worship.
27A, Lordship. 27 is not
ADPS Act.
Yes,
under the mandate of 37, but 27A is, Lordship.
NDPS.
You just read.
Okay, Your Worship. Your Worship, 27A, punishment for financing illicit
Financing illicit traffic,
and harboring offenders, Your Worship.
harboring of offense.
Yes,
See, two things.
Oh,
yes,
yes, even that he harbored one of the accused, Lordship.
Is it?
Yes. In this statement, this is investigation stage. After charges, certainly more section will frame against him, I'm very sure. In this case, he is not the first timer. Even when he was arrested, that was under NDPS Act, ganja. The one that is reflected in the instruction received.
no recovery was made, Your Worship.
But this is investigation stage.
Yes, investigation will go on, Your Worship. It may take years also.
Prima facie, of course.
Prima
Prima
facie.
facie, 27A may not attract here in the case.
Yes, Your Worship.
See the FIR, see the FIR.
Yes, in the FIR also, my name is not being reflected, Your Worship.
No,
FIR
during the
not
course of
name, of course,
investigation,
that
he
is
was
different, but then of course, but then you see subsequently, although he has been arrested on the disclosure made by co-accused, the main
Yes, Your Worship.
accused, but then subsequently he himself has admitted, and in
Yes.
your petition also,
Yes, Your Worship.
you yourself admitted that you have delivered a bag
Yes, Your Worship.
containing that.
I don't know what was
that-
content.
Although you say that you don't know,
Yes, Your
but
Worship.
then it is admittedly that you delivered,
Yes,
and
Your
then
Worship.
which contain
On
the-
one occasion only, Your Worship, one occasion.
one occasion, that is
Yes.
one occasion, of course, but then you see, and then if you see his statement.
Hmm.
Let us see the statement. Oh, this statement is not in
last page, Lordship.
last page.
Yes.
Hmm.
The first paragraph talk about his family background, and then his the antecedent arrest.
Yes.
The second talk about the present case.
Hmm.
Shall I read out or
Yes, but which one?
statement?
Which,
Last page.
last page?
Yes, his statements on last page.
Okay. Yes.
Name James, James Shanjam, father's name and so.
No. Okay, okay, we'll just read it, huh? This is still under investigation.
Yes, yes.
Let us just read, huh? Silently. So I was born so and so. No, no, it's 5 month jail sentence, he said.
Yes, but.
It's not a sentence, I think. It's not because it was probably during the investigation period only.
Yes.
Maybe
He didn't know, because it says records in this, as per the, the report of the IO, he's on bail. And they say details will be submitted.
Yes, he says jail sentence, but it's not a jail sentence.
Yes, Your Worship. Conviction is not.
Uh, Probably you might have not seen. Clearly, you see, reveal his involvement.
In the
It's
present,
not that he doesn't know. He
Your
did
Worship,
not know. It's
Your
not-
Worship, the difficulty of section 28, 27A, the explanation, Your Worship, one transaction does not mean, and harboring, there is nothing there, Your Worship. Harboring that's also has been explained, Your Worship. I know the co-accused, Your Worship, just because of the statement of a co-accused, Your Worship.
No, it's not. You are
And Your
involved.
Worship.
You are involved. Already. Have you gone? You have not.
No, Your Worship,
Oh.
but Your Worship, this statement cannot be used.
Cannot be used.
Just basing on a statement, Your Worship.
Mm.
I cannot be convicted,
But
Your
but
Worship.
you see, you have been informed. He was involved,
Yes, Your Worship.
but he did not know what was the content.
Mm.
But in here he has revealed everything.
Yes, Lord. Okay, Your Worship. But Your Worship, one cannot be convicted just solely on the basis
Conviction,
of
of course, that is different. That
Yeah.
is different.
that
He
is
may
the
not
most
be-
key
he
factor,
may
Your
not be
Worship.
Convicted.
Key factor here, Your Worship. If I may
But
place one,
prima facie at the moment,
yes,
for
Worship.
the time being, on going through this statement and on admission also, it's very difficult.
Oh, Your Worship, if I may be allowed to place this 2019 volume 3, Your Worship. Page 873.
So what it says,
Here, also in this present case, Your Worship, a commercial quantity was seized, Your Worship. And then one of the co-accused named the petitioner as he has been involved. And then section 37 was involved. Your Worship, while dealing with section 37, this court has come up of this reportable judgment, Your Worship. Paragraph number 6, Your Worship. Page number 837. Paragraph
Yeah.
number 6,
Mm.
it speaks about section 37.
Yeah.
And paragraph number 7, Your Worship. In this case, it was since it was a commercial quantity, so a similar provision on bail has been invoked under section so and so of Maharashtra Control so and so, which also is as under. Your Worship, you can see it's notwithstanding
where
clause.
are you reading?
Paragraph number 7, Your Worship.
7?
Yes.
I thought 6. Okay.
6 to section 37, Your Worship.
Okay, yes.
7 also in similar restrictions in other
Provision,
act also.
Similar provision.
Yes. And Your Worship, in paragraph 9, the observation was made. Here, Your Worship, the apex court was of the opinion that restriction imposed under section 21 of the Maharashtra Control of Organized Crime Act 1999 does not imply that the court must give a positive finding that the person seeking bail has not committed the offense. The apex court was of the view that if the court, on the basis of material brought on record, is satisfied that in all probability the accused may not be ultimately convicted, an order granting bail may be passed. It is further held that the satisfaction of the court as regards the likelihood of not committing any offense while on bail must be construed to mean an offense under the NDPS Act and not any offense whatsoever, be it a minor or major offense. It further observed that for the purpose of considering the application of grant of bail, although detailed reasons are not necessary to be assigned, the order granting bail must demonstrate as to why the bail has been granted or denied. The court also observed that the duty of the court at this stage is not to weigh the evidence meticulously, but to arrive at a finding on the basis of broad probabilities, Your Worship. And Your Worship, I will just go to paragraph number 11, Your Worship, because in the next one, the court has held this one. One must not lose sight of the fact that rejection of bail ultimately affects the right to liberty of a person. Though the right to liberty enshrined in Article 21 of the Constitution is not absolute and is subject to reasonable restrictions, in order to deprive a person of his liberty, there must be a reasonable ground. Article 21 of the Constitution cannot be put to challenge on fanciful ground or in a light manner. Your Worship, in my case, I'm saying I'm a victim of circumstances, Your Worship. And section 37 is the main one, Your Worship. So, Your Worship,
If section 37 does not apply,
yes, Your Worship.
then you see, and then if it was
Section-
not a commercial quantity,
Yes, Your Worship.
then
Then section 28 survives, Your Worship. What section 28 of the NDPS is just an ancillary section, Your Worship. So when the charge sheet is filed,
the 27 not.
yes, section 28, Your Worship. 28, punishment for attempt to commit offences. So your worship, it's an ancillary clause. So when the charge sheet is filed against me and another section has been moved, I'll send a trial on that one, your worship. Here, your worship, the application of section 37 is the main problem, your worship. Your worship, section 27A also, your worship. It has been, yes,
27A.
yes. It has to be read along with clause 28B, your worship, which has explained illicit trafficking. Your worship, in Ria versus Ria Chakraborty versus this Union of India, your worship. The provision of section 27A has been discussed properly, your worship. Even though it's from a different high court, your worship, it has been discussed meticulously here, your worship. While we are on section 27A, your worship, if I mean, we're allowed to place that Ria Chakraborty case, your worship.
Just a minute. Yeah.
Okay, your worship.
Twenty-seven A probably is not attracted.
It is attracted.
Hmm.
Because harboring is already there as per his own statement. He harbored the main accused. Even otherwise, investigation is still going on, Lordship.
And the next is, your objection is 27AN.
Main clause is section 27A, your worship. If the applicability is not there in this present case on the interpretation of the high court's, your worship, other high courts also, then my case falls under this one, a default bail, your worship. It's just because of the interplay between section 27A and section 37,
So then-
37, I cannot even apply for a default bail, your worship.
Then if it is not applicable, then what I was thinking is that you
Yes,
are.
worship. Prima
you're
facie,
entirely
prima
for
facie.
default bail. But then you see, if it is applicable, then it drop.
Yes, your worship. So, dropping on of all those, your worship, at that, after charge sheet has been filed, we'll see, your worship, what the investigating official is charging me formally against specific allegations or so. Right now, there's only two sections, section 28 and 27A and 28, Your Worship.
But then under the circumstances, also considering that your case and on medical ground also and on merit also, your case has been rejected.
Your Worship, on merit, it was not discussed properly on by the learned session judge. That's why I'm here, Your Worship. Even though I have prayed, but it was not considered here. That's why
No,
because of the
what is
the interpretation.
Second bail application was for?
Second bail application was for merit, Your Worship, but,
Yes.
but it was not discussed properly and a reason order was not passed, Your Worship. That is the difficulty I am facing, Your
What
Worship.
more reason you want for rejection?
Your Worship,
Considering the material found on record.
yes, Your Worship.
And
That's why,
then
Your Worship.
In the record,
Record, Your Worship.
I also don't have to reveal everything
Yes,
in the
Your
order because in the record, whatever is
Your Worship,
available on
to
record.
attract section 27A, on a broad probability, Your Worship, there are no sufficient evidence against me. That is my,
Sufficient or not, you see, prima facie, if there is there,
yes,
if there is a case against the accused persons
yes, sir.
on record being produced before the court, on perusal of that record, if there is a prima facie case found by the court, then you say, you don't have to go to detail, whether he will be convicted or not, may not be required at the moment.
Yes, Your Worship, but Your Worship,
Because that will be different after filing of charge sheet and after trial, he may be convicted or he may be acquitted also. But then if prima facie, if there is a material against the accused for commission of the alleged offense, and in the instant case, there is, you see, he himself is categorically stated. Categorically.
yes,
And then you say, you also say, of course, fairly admitted that delivery was there. And then
Yes,
here in the police statement, he has revealed everything, how it happened.
yes, Your Worship.
So it was not that, it's not a case that he did not know what was the intention. And then there is a plan, then execution
Yes,
is there.
those things will be,
Yes. that
yes,
is
Your
there.
Worship.
So then.
Your Worship,
no-
let me
not
please,
doing the things.
this one,
Involved. Then under the circumstances, how do we consider?
Your Worship, I will, scope of section 27A, you, let me go into the, Your Worship.
Now,
Uh,
now, Lani Council, you say, now the matter is still under investigation,
Yes,
active investigation.
yes, Your Worship.
There are a lot of people involved in
Yes,
this
Your Worship.
case. People are being arrested,
Yes,
including, of course, you. More, I think some around
11 already arrested.
11.
Yes.
So the persons are involved.
Yes, Your Worship, Your Worship. The, Your Worship, the thing is that, Your Worship, on just, there is one confessional statement, Your Worship. There is no recovery. Now, Your Worship, will I be convicted on the basis of a confessional statement?
No,
Right
he-
now, Your Worship, we will not
he-
go into the merit, Your
He
Worship.
himself has said deliberate.
Yes, Your Worship.
You see, he got the money also. Money, where he spent the money also, he has stated. 30 plus he has spent it somewhere, and then the rest he spent for household. He has categorically stated. Difficult.
Your Worship, then, let me just go to the scope of, this
Yes.
section 27A.
Okay.
Yes. Your Worship, I'll be placing, 2021 Criminal Law Journal, 248, Your Worship. It's a Bombay High Court, this one, Your Worship.
Yeah.
Ria Chakrabarti, yes. Here, the scope of section 27A has been discussed, Your Worship.
Yes.
I would like to, just like to highlight at page number 263, Your Worship, paragraph number 49. Paragraph number 49, Your Worship, 263.
Page
263, Your Worship,
49, okay, got it.
paragraph number 49.
Yes.
Scope of section 27A of the NDPS Act, Your Worship. Another important question of law which is required to be addressed in this case is the scope and interpretation of section 27A of NDPS Act, Your Worship. Section 27A reads thus. Before that, Your Worship. In this case also, before the charge sheet was filed, the accused was granted bail, Your Worship. So here, Your Worship. So section 27A, punishment for financing illicit trafficking and harboring offenders, Your Worship. Whoever indulged in financing directly or indirectly any of the activities specified in subclause 1 to 5 of clause 8A of section 2 or harbors any person engaged in any of the aforementioned activities shall be punishable with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years, and shall also be liable to fine which shall not be less than 1 lakh rupees, but which may extend to 2 lakhs rupees, provided that the court may, for reason to be recorded in the judgment, impose a fine exceeding 2 lakhs, Your Worship. Your Worship, 49. Paragraph. And it continues, Your Worship. So definition in this act, unless the context otherwise requires, illicit traffic in relation to narcotic drugs and psychotropic substance means cultivating any coca plant or gathering any portion of coca plant, cultivating the opium poppy or any cannabis plant, engaging in production, manufacture, possession, sale, purchase, transportation, warehousing, concealment, use or consumption, import interstate, export interstate, import into India, export from India, or transshipment of,
Transportation, huh?
oh, yes,
Kindly note it, transportation.
transportation, yes, Lordship. Transshipment of narcotic drugs or psychotropic substance.
Transshipment.
Yes. Dealing in any activities in narcotic drugs or psychotropic substances other than those referred in to subsection 1 to 3, or handling or letting out any premise for the carrying on of any of the activities referred to in subclause 1 to 4, other than those permitted under this act, or any rule or order made, or any condition of any license term or authorization issued thereunder, and includes financing directly or indirectly any of the aforementioned activities, abetting or conspiring in the furtherance of or in support of doing any of the aforementioned activities, and 3, harboring persons engaged in any of the aforementioned activities. Your Worship, then this 54. 50, Your Worship. As per the NCP case, the applicant financed procurement of drugs for so-and-so, and she harbored him, knowing that he was consuming drugs, and therefore she has committed the offense punishable under section 27A. As discussed earlier, rigors of section 37 of NDPS Act specifically applies to section 27A, and section 27A is independent of quantity involved. There is no mention of activities involving small, intermediate, or commercial quantity in section 27A. Therefore, what is required to be considered is what is meant by financing and harboring, Your Worship. Section 28A defines illicit trafficking, giving a list of various activities. Clause 1 to 5 in section 28A are referred to in section 27A. Clause 1, 2, 3 are reproduced at verbatim in subclause A, B, C of the prohibitory section 8 of NDPS Act. In the present case, the applicant is not concerned with subclause 1, 2 of section 28A, or clause A, B, subclause A, B of section 8 of the NDPS Act. Subclause 3 of section 28A and subclause C of section A requires close scrutiny. Section 8 prohibits certain activities, and it lays down that no person shall produce, manufacture, possess, sell, purchase, transport, warehouse, use, consume, import interstate, export interstate, import to India, export from India, or transship any narcotic drugs or psychotropic substance. These all activities are included in subclause 3 of section 28A except concealment, which is missing from section 8C. However, that would be perhaps covered under the residual provision of subclause 4 of section 28A. Contravention of section 8 is made punishable under various provisions of NDPS Act, section 20, 21, 22, and importantly, all this penal section takes into account the quantity of the contraband to prescribe a particular sentence. The penal section, like section 19, 24, 27A, are not quantity specific. They make no reference to quantity of the substance involved. Your Worship, the legislature was clear in its intention to give concession in the sentencing structure for smaller or intermediate quantities of contraband. If section 27A is applied to activities mentioned in section 8, 18 to 20B, 21, 22, and 23, then the classification of the offenses for sentencing purpose depending upon the quantity will lose all its significance. Section 27A is a different provision, though the activities mentioned in this section are common. Section 27A is much wider if subclause 4 of section 28A is taken into account. This subclause 4 and section 2AA takes in its sweep all the remaining activities which are not mentioned in subclause 1, 2, 3. This covers just about every activity which can be described as dealing in narcotic drugs or psychotropic substances. The interpretation of section 27A should not be stretched to the extent of rendering classification of sentences depending upon the quantity in penal section 20, 21, 22, and 23 or OTOSHIS. Subclause 8A of section 2 of the NTPS Act is an inclusive definition. The inclusive part meaning financing, abetting, or conspiring and harboring. The financing and harboring part are specifically made punishable under section 27A. The activities mentioned in section 2AA, 3 and 3 and section 8C refer to sale, purchase, export, import, etc. All these activities involve monetary transaction. For every sale or purchase, there can be use of money, but that will not mean that either of the parties has financed the transaction. Such sale and purchase are separately prohibited and made punishable under section 8C, read with section 20 and other similar sections. Therefore, financing is something more than just paying for purchasing or other activities involving contraband as defined under section 8C. Contravention of that section and indulging in activities mentioned in section 20, 21, 22, and 23 incur punishment depending on the quantity of contraband. For interpreting section 27A harmoniously with the scheme of the Act and other sections, it is necessary to go to the statement of the object and reason for incorporating this section in the Act with effect from 29/5/1989. The statement of objects and reason of 1989 amendment, which is reproduced here in below, mentions that India was facing a problem of transit traffic and illicit drugs. The spillover from such traffic was causing problem of abuse and addiction. Therefore, need was felt to amend the law and further strengthen it. Thus, the aim was to control the traffic in illicit drug as a spillover from such traffic was causing problem of abuse and addiction. The legislature wanted to attack the basic cause of illicit traffic of drugs. The prohibitory section 8 was already existing at that time. Therefore, a separate section 27A was introduced to check these activities, which were the root cause of illicit trafficking. Finance and harboring such activities were therefore specifically mentioned under section 27A. Financing is not defined under the Act. The concise Oxford Dictionary defines the word finance as 1. The management of especially public money. 2. Monetary support for an enterprise. 3. In the money resources of a state, company, or a person to provide capital for a person or enterprise. Black's Law Dictionary giving meaning to the word finance as to raise or provide funds. Thus, financing, as generally understood, is offering monetary support or provide funds. Therefore, simply providing money for particular transaction or other transaction will not be financing of that activity. Financing will have to be interpreted to mean.
We are not probably concerned with the financing. We are
Yes.
concerned with the harbor, I think.
We'll come to that. It has also been explained here, Worship. So we'll just continue, Worship. Financing will be interpreted to mean to provide funds for either making that particular activity operational or for sustaining it. It is the financial support which directly or indirectly is cause of existence of such illicit traffic. The word financing would necessarily refer to some activities involving illegal trade or business. Your Worship, then page numbers, paragraph number 63, Your Worship.
Yes.
The word harbor that was not even defined in, Your Worship, my apologies, paragraph 62. The next keyword in section 27A is harbor. Again, harboring is not defined under NDPS Act. The expression harbor is used in other acts as well. One such act is Terrorist and Disruptive Activities Prevention Act 1987, short for TADA. Subsection 4 of section 3 of the same act reads thus. Punishment for Terrorist Act, whoever harbors or conceal or attempts to harbor or conceal any terrorist shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to fine. The word harbor was not even defined in TADA. The Honorable Supreme Court has an occasion to address this issue, which was reflected in the case of Kalpanath Rai versus State through CBI. In that case, it was contended before the Honorable Supreme Court that the word harbor, which was not defined in TADA, must be understood in the same manner as it was understood in Indian Penal Code. The Honorable Supreme Court did not completely agree with such contention, but went on to make certain important observations in paragraph so-and-so, read thus, Your Worship. There are two hurdles in the way to adopt the IPC definition of the word harbor for TADA. First, that the TADA permits reliance to be made only on the definition included in the procedure code and not on the definition of in the IPC. Second, in the word harbor as such has not been used in the procedure code, and hence the question of sidestepping the penal code definition does not arise. Be that as it may, we would prefer to refer to the expression harbor as understood in IPC for TADA is essentially a penal statute, and hence the meaning attached to the word in IPC can have a bearing on the words used in TADA, unless they are differently defined in the code. Section 52A of the Indian Penal Code defines the word harbor as including supplying a person with shelter, food, drink, money, clothes, arms, ammunition, or means of convenience, or the assisting of a person by any means, whether of the same kind as those enumerated in this section or not, to evade apprehension. Section 136 and 312 of IPC are the provisions incorporating two of the offenses involving harbor, in which the common word used are whoever, knowing or having reason to believe. Another offense in the penal code involving harbor is section 157, wherein also the word whoever harbors, knowing that such person, etc., are available. It was contended that mens rea is explicitly indicated in the said provision in the penal code, whereas no such indication is made in section 3(4) of TADA, and therefore the element of mens rea must be deemed to have been excluded from the scope of section 3(4) of TADA. The word harbor used in TADA must be understood in its ordinary meaning. As for the penal provisions, in Black Law Dictionary, its meaning is shown as to afford lodging, to shelter, or to give refuge to. Quoting from Sonos, right, US so-and-so, the celebrated lexicographer has given the meaning of the word harbor as receiving clandestinely and without lawful authority a person for the purpose of so concealing him that another have the right to the lawful custody of such person shall be deprived of the same. In the other dictionaries, the word meaning of the said word is delineated almost in the same manner as above. It is therefore reasonable to attribute a mental element, such as knowledge that the harbored person was involved in a terrorist act, as indispensable to make it a penal act. That apart, there is nothing in the act, either expressly or even by implication, to indicate that mens rea has been excluded from the offense under 3(4) of TADA. Section 219 of NTPS Act also permits the use of CRPC to assign meaning to words and expression. The Honorable Supreme Court mainly discussed whether mens rea was applicable. Even in Section 27A of NTPS Act, the concept of mens rea is applicable. The section of 52A of IPC can be used for a limited purpose as mentioned by the Honorable Supreme Court. The key word in that section are to evade apprehensions. This only means that, first of all, there has to be another offender who has committed the offense. The person who is charged with harboring that main offender should have supplied him.
I think we're running out of time. We have to conclude now. So, this is with regard to the
Harboring, Your Worship.
harboring and then definition in Tata.
Yes. And also now it's the NDPS Act, Your Worship. So basically, there must be an accused who is absconding from the law. And I must provide him with food, shelter, and so on, to mean that I have harbored a person. A person just coming to my home and spending one night without any, who is not evading law, cannot be termed to has been, cannot mean that I have harbored that person, Your Worship. And as I've also said, the co-accused is an acquaintance of mine. He may have visited my place from time to time. But that doesn't mean that I have harbored him in any way, Your Worship. I am a family man living separately with my own family, Your Worship. And in this case, Your Worship, just because of the circumstances, I am now languishing in jail, Your Worship. And this applicability of Section 27A has made it more difficult for me to come before the court for bail, Your Worship. And the investigation may go on, Your Worship, for however long, I do not know. But just because of this, I am facing difficulty, Your Worship.
You have anything?
Yes, Lordship, as far as the citation which my learned friend cited is a Ria Chakraborty case. There's facts of the circumstances are very different from this. Now, my lord, we remember that Sushant Singh Rajput, he was a celebrity, he committed suicide. Then the lady was his girlfriend. Now he financed, as per the case, he financed procurement of the drugs for the consumption of her boyfriend and let her stay in her house. That much. How she was 27A and 337 was so well discussed in this. And the fact is that the fact was that now, if my lord may look to the I don't know, the one I have is SCC online. Last 4 or 5 paragraph, the commercial here in this case, the conclusion of the finding of the Bombay High Court is now there was no antecedent of the girl. And now, even now, the material of the highest shows that she has committed an offense involving contraband, but the crucial element of incurring rigors of 37 in respect of commercial quantities missing because it's only for the consumption of her boyfriend. Then,
in which case?
Last page.
This case?
Yes, Ria Chakraborty.
Okay, okay.
And then there was no commercial. There are no other criminal antecedent against her. She's not part of the chain of the drugs dealer, unlike here. And here he has a precedent. He has a history of chain dealers. Then also, she has not forwarded the drug allegedly procured by her to somebody else to earn monetary or other benefits. She has not done that. Whereas in our case, he has done that by his own admission. So now the learned judge before the High Court of the High Court was under conviction that he was believing that she is not likely to commit any offense while on bail. Because
that is in para?
Last 1, 2, 3, 4. Last four. Mine paragraph is 86. But I think it is SCC online.
Okay. It start with?
Start with 86. It's a length.
Sentence start with?
Sentence starts with
the allegation.
The allegation. No, below that, Lordship, just below that, the allegation. The main section. Yes, yes.
Okay, okay.
So in that, everything is there. So the facts are very different, Lordship. So here, now the mandate of Section 37 is such that my lord has to believe that he has not, in the first place, he has not guilty of, the accused has not guilty of offense, that my lord has to be satisfied. And again, that he also, my lord has to satisfy that he's not likely to commit any offense while on bail. Now, in the Ria Chakraborty cases, her boyfriend's already expired. There's no likelihood of any committing further offense, Lordship. So the facts and circumstances are very different from this case. Though our Section 27A is well discussed in this case, The facts and circumstances of.
Yes, Your Worship. I also admit that the facts and circumstances are completely different. My case, Your Worship, there was no recovery, Your Worship. In that case, there was some recovery and there was something to show that there was a direct involvement
No,
of.
no, no, there was no
contraband,
recovery,
Your Worship.
no recovery. And what the CBI's, what the custom taken was, it was already consumed. That was the
See, Your
sentence.
Worship. Out in my case, Your Worship, there is nothing material on record to show that I have directly dealt with any kind of contraband. It's only an allegation, Your Worship, and a statement of co-accused. Now, basing just on the statement of co-accused and my statement also, Your Worship, the conviction in this kind of cases is highly improbable, Your Worship. That is my case, Your Worship. It's very improbable. Just because of my confessional statement and this statement. And Your Worship is aware that the confessional statement cannot be used
And
without corroborating evidence, Your Worship. There's no corroborating evidence against me in this
there is,
presently, Your
there
Worship.
is, Lordship, there is, my lord.
So that any conviction.
Well, here, what do you want to show?
Lordship, paragraph 5. This is SCC, it's a law case. Paragraph 5, coming to the section, this is before the amendment was made, before the amendment of incorporating into 27A. All this is, but the substance has not been changed, and this has not been, the rule has not been, the laws laid on has not been, as far as I know, overturned, Lordship. Now, I'll take my lord quickly to the point where I want to point out the last page, paragraph 5, last sentence, Lordship.
Negation.
Yes. Negation of bail is the rule, and its grant an exception under subclause 2 of clause B of section 37(1), Lordship. This is the law. Then for granting the bill, the court must, on the basis of the report produced, before it be satisfied that there is reasonable ground for believing that the accused is, all these things are there. Then the last sentence in the same paragraph, Lordship, liberal approach in the matter of bail under the act is uncalled for. That is the Supreme Court says. And also, this is the first issue addressing section 27A and 37, Lordship. And again, coming to the filing of subsequent petition, Lordship, paragraph 8. Paragraph 8. This is also. It has further to be noted that the factum of the rejection of his earlier bill application bearing miscellaneous so and so has not been denied by the respondent. Same case here.
No, Your Worship, I am denied, Your Worship. My case was not considered on reasonable on the fact on the precedence of the honorable court, Your Worship. That's why I'm here, Your Worship.
Lordship, and here
The facts are not denied, but the question of law, the interpretation has been denied for my case, Your Worship.
okay, anyway, let me first continue that sentence. And in the same, then it is true that successive applications are permissible under changed circumstances, but without the change in the circumstances, the second application cannot be would be deemed to be seeking a review of the earlier judgment, which is not permissible under criminal law, as has been held by this court in Hari so and various other judgments, Lordship. So in the light of this, now investigation is going on. If my lord has already perused the instruction received, now he is. If my lord, I'm sorry, I'm taking my lord time, but if my lord go back to the instruction received, now he is the second last paragraph, the second last page and the second last paragraph. If we peruse here, through the investigation, a prima facie case was established against him that he was actively participating in the drugs.
Where are you reading?
Last second paragraph, Lordships.
Okay.
Last second page.
Okay,
Yeah.
okay, yes.
Third sentence, Lordship. Before that, maybe second sentence. During
Yes.
examination under police remand period, he voluntarily discloses involvement in the illicit
That's
trafficking.
my statement again, Your Worship.
Through investigation, a prima facie case was established against him that he was actively participating in the drugs business with many associates, procuring from Manipur and supplied it to Nagaland. He was also found well connected with the upward and downward linkage of the drug chain. So far, 11 persons were arrested in this case, connection including James, the present accused. That, Your Honor, and accused the present James was not arrested for a mere suspicious but on sufficient grounds of his involvement in drug trafficking that I strongly object his bail in any form and humbly pray like this, Lordship.
Your Worship, let me summarize, Your Worship.
Okay.
Just 5 minutes, Your
I
Worship.
think that's not.
Your Worship,
you have
just
submitted
a few minutes, Your Worship.
Yes.
Your Worship, Your Worship, I will stand the trial when a formal charge sheet is filed against me, Your Worship. However, at the present, Your Worship, I'm languishing in jail only on interplay between two sections, Your Worship, that is section 27A and 37. Your Worship, I've placed before Your Worship the views of the other high courts and also the view of this high court in dealing with cases where section 37 of the NDPS Act applies. I'm not saying make a liberal this one, Your Worship. This is a settled principle, Your Worship. And so I pray that Your Worship will, after considering the facts of the present case, grant bail to the petitioner, because Your Worship, there's no material on record that the applicant has directly dealt with any kind of contraband, and there's on mere allegation that he's under custody, Your Worship. And only confessional statement, two confessional statement, that is one is mine and another is of a co-accused. That is the only thing against me, Your Worship, to show that I have been involved in section in NDP contravening NDPS Act, Your Worship. And section 27A is for illicit trafficking and harboring, Your Worship. That is the main one, Your Worship. Section 28, as I said, I will stand trial, Your Worship, when the formal charge sheet is filed against me. But for granting of bail, Your Worship, the central principle is there, Your Worship. A reasonable and detailed order should be passed, Your Worship.
Okay.
Yes.
Lordship, this additional just one point of.
Para.
Lordship, I correct.
Mark the para.
Yeah. 2023, Lordship, yes. On 37.
So I'll pass on that, Lordship.
Lordship.
If required for any clarification will be otherwise it will dispose of only today, unless of course there is anything.
Okay, Your Worship.
Pass order. Maybe Twitter is dispose of only.
Okay, Your Worship. Bless you. It's just